and if there's any discussion or objections to it, please let me know. Otherwise, we will consider those minutes approved. Not seeing any, please show the minutes approved, Mindy. First up, we're going to have a hearing on 2107, providing for claims to recover damages from fire events caused by electric public utilities. Nick, fill us in on what we're doing, sir.
Certainly, Mr. Chairman. Good morning, committee. Committee, House Bill 2107, this, as the chairman stated, relates to electric public utilities and any unplanned wildfire events that may occur due to some type of negligence or some other conduct from the electric public utility. So just real briefly, and then I'll get into it, into each item here in a sec. This bill would establish a new statute to establish a specific statute of limitations for wildfire-related claims to be brought against a public utility. It would authorize recovery of certain damages and then also limit the calculation of damages to real property and how that recovery is undertaken. It would also then finally require the State Corporation Commission to conduct trainings and essentially open a docket on wildfire risks and mitigation strategies. So let's get into the section 1 of the bill. This is the section that deals with the fire claims. So section 1, subsection B, would establish a 2-year statute of limitations for any civil action that's brought against an electric public utility relating to a fire claim. And in the bill, a fire claim is defined as any civil claim, whether this is based on negligence, nuisance, trespass, or any other civil claim for relief that's brought against an electric public utility with respect to an unplanned or out of control fire event. This statute of limitations would begin to run on the date that the fire was first ignited pursuant to the bill. Then committee, turn your attention to subsections C and D of the bill. These specifically subsection C, this would authorize an injured plaintiff who establishes by a preponderance of the evidence, and that's the current negligence burden of proof, so the same burden of proof that would apply in any negligence action. If they establish by a preponderance of evidence that a loss was caused by a fire event and caused by the electric public utilities actions or inactions, that the plaintiff can recover economic losses to compensate for damage to property. And then the bill goes on in subsection D to state how damages to real property shall be determined in these fire claim actions. So under the bill, if there is damage to real property, the bill would specify that the plaintiff would be authorized to recover the lesser of the cost to restore the property to the property's original condition before the fire, or the difference between the fair market value of the property before and after the fire. These, again, are very similar to how recovery is done for property damage in typical negligence suits. Then finally, from Section 1, Section 1E would establish a punitive damages cap in the amount of $5 million related to any fire claim. This is very similar to the current punitive damages capped in the civil procedure statutes. And I will note that my memo should reference 60-3702E because that is the statute that currently establishes a similar punitive damages cap in civil actions and up to $5 million. And then moving on to Section 2, Mr. Chairman, real quick, as I stated, Section 2 would require the State Corporation Commission to provide trainings and opportunities to assess wildfire risk and utility mitigation efforts. This would include wildfire risks in the state, looking at utility readiness to mitigate such risks, some mitigation strategies and approaches that can be taken, and then how cost recovery should be treated for any mitigation efforts. And this would likely take place in a open docket proceeding through the State Corporation Commission. If this bill is enacted, Mr. Chair and members of the committee, this would take effect on July 1, 2025 upon publication in the statute book, and I'd be happy to stand for any questions.
Thank you, Nick. Body, do we have questions for Reviser? Mr. Carmichael.
Thank you, Mr. Chair, and thank you, Mr. Myers. I appreciate the assistance you provided me on short notice with respect to this bill. I do have a few specific questions at page 1, line 19 and 20. That is where it describes a 2-year statute of limitations. If I look a little higher in the bill, fire event, fire claim, I think, it's in here somewhere. It says it includes trespass. Trespass is typically thought of, I believe, as an intentional tort and subject to a 1-year statute of limitations. Would this bill actually extend the statute of limitations so people would have, in some circumstances, a longer period of time to sue the utility for its trespass or intentional conduct?
So that is possible. Representative Carmichael, if you look at 60-513, this is the statute of limitations for essentially negligence actions. It also, subsection A1 does state that an action for trespass upon real property is also subject to the 2-year statute of limitations, but there certainly might be another intentional.
Shows what happens when it's 40 years or more since I graduated from law school.
There's a reason why I printed this statute off. It's for you.
It always helps to warn the reviser about what you're going to ask about.
Yes, I do appreciate that.
60-3701E down in line 35. Did I hear you say that the punitive damage limitation of $5 million in the current law is in 3702 as opposed to 3701?
Yes, that is correct. I would advocate for a technical amendment because that 60-3701E actually applies to actions that took place prior to July 1, 1988, and then there was a commensurate statute, 60-3702, that was adopted later, and the bill should reference that updated statute.
That's what we call a good catch, and we ought to do a technical amendment on that.
Yes, thank you. Thank you for pointing that out.
Final, I think the final question that I have for you at least is the 2-year statute of limitations described here at lines 19 and 20 on page 1. I believe it says it begins to run on the date of the ignition of the fire. So if a fire starts, I was going to say Oklahoma, but Evergy doesn't work in Oklahoma, but Oklahoma Gas and Electric. If the fire starts on Thursday, but my barn doesn't burn until Saturday, I've got to sue within 2 years of Thursday rather than the date upon which the damage actually occurred. Is that correct?
That is quite possible. I know that statute that I referenced, 60-513, does specify some language about the tolling of the statute of limitations and when it begins to run. But this certainly would be a de facto requirement that the statute of limitations begins to run on the ignition of that unplanned fire event.
And finally, Mr. Chair, my recollection is that we have tolling provisions for the statute of limitations, one of which is not having discovered the loss would be an example. But this appears to be different because this lays a trap for the unwary. It says it doesn't matter that your barn burned down on Friday. If you don't have your lawsuit filed 2 years after Thursday, you're out of luck. Is that your interpretation?
I think that is quite possible under the provisions of this bill.
Thank you.
The interaction between 60-513 and this probably might need some consideration a little bit.
I appreciate your help. Thank you.
Good questions. Further questions, Bonnie? Not seeing any. Okay, thank you, Nick. Appreciate it. First up, we're going to have Chuck Casely with Evergy. Welcome to the committee, sir.
Mr. Chairman, Ranking Member O'Hobson, members of the committee, I'm Chuck Casely with Evergy, and it's a pleasure to be here this morning, and thank you very much for the opportunity to hear this bill. It's about 1.25 pages We're trying to be as straightforward, short and simple as we possibly can. There's really two sections and two goals. The first is to, as straightforwardly and non-controversially as possible, take what are the negligence standards and common law applications in this area and codify them into statute. There is one area of new law regarding property damage. I'll talk about that in a little bit. It's probably the most controversial part of this proposed legislation. And the second thing is we would really like to have a formal proceeding in front of the Kansas Corporation Commission to discuss wildfire risk mitigation and to make sure that the state is thinking proactively about something that could have a devastating impact on the economy. In my written testimony that I put in this morning, you'll see there's a map there, and it has the FEMA designation for Kansas, where there are significant portions of the state that are designated moderate to high risk of wildfires. In states all over the United States where FEMA has designated a high risk of wildfires, or alternatively, they've had pretty devastating wildfires, you see legislation proposed by utilities and oftentimes coalitions of groups to deal with the litigation and the risk coming out of these events. Specifically in California, Oregon, Washington, Colorado, and Utah, states with very high wildfire risk, they've either passed legislation similar to this or are actively pursuing it this session. Really, what we want to do is make sure in statute that we spell out the legal standard for utilities and that we also do an assessment of the risk and proper mitigation that utilities should be taking in this area. So utilities, you might wonder why this is such a huge concern. Well, utilities and how this relates to customers. Well, utilities and specifically electric utilities are some of the most capital intense industries in the United States, which means on an annual basis, we spend hundreds of millions and sometimes billions of dollars investing in the generation and the transmission and the delivery of electricity. That is financed. We borrow that money, and that money and the capital cost or the interest rate associated with it has a huge impact on customer rates, sometimes hundreds of millions of dollars. So the intent here today is to make sure that if a wildfire was to occur, that we are making sure financially that utilities can remain strong and continue to pursue the important infrastructure role that they play in the state. The second thing is we want to make sure that utilities, this is acknowledged in law, so that when people make decisions on whether to invest in Kansas and invest in electric utilities to provide the infrastructure in this state, they understand what the risk metrics are. And then thirdly, utilities are a little bit unique relative to other businesses in that we don't really have a super significant way, a good way to mitigate wildfire risk. Why is that? Well, we can't choose our customers. That means if you're in a high wildfire area, we serve you whether or not it's risky. It means we can't turn off our electricity in times of drought or in times of high wind or in times when both conditions are present. And for us, with over 10,000 miles of transmission and 50,000 miles of distribution lines, there's almost no way to physically secure and mitigate the chances something could happen on that system 24 hours a day, 365 days a year. And so putting what is already Kansas law into statute has some significant impacts as people look to invest in us and in the capital for the infrastructure of the state. So I want to first start with section 1. First, what is very important to know is we are not capping, changing, or touching anything that has to do with economic damages or non-economic damages resulting from fires, with the exception of property damage, which I'll talk about here in a minute. That means whatever your economic damages are, if a wildfire was to occur and you were to sue the utility because you believe that we were responsible, then those economic damages are not capped. Same thing with non-economic damages. The only thing this addresses as it stands today is property damage and the standard under which this will be applied. So let's go to the first aspect. The first aspect is the standard for this currently under common law and in case law in Kansas is the negligence standard, meaning that in order to hold us liable, you have to show beyond a preponderance of the evidence that an action of ours caused, or something we did was negligent and caused the fire. Now, some may say, why put that into statute? Well, there's really two reasons. First of all, plaintiff's attorneys, and I'm a recovered attorney, will often take a look at facts of cases and say, you know what, we understand what the lineage of the case law is. We understand what it is today, but here's why that doesn't apply. If you put it into statute, then there's no question. It's the law of the land. So we're simply codifying what is the standard today, putting it into the statute so that it can't be eroded over time by the courts. The second thing, though, is we're a multi-state utility. And what folks like to do often with us, because we have operations in Missouri, is something will happen in Kansas, but in Missouri, where you don't have as solid of judicial system as we do in Kansas, they like to remove it to Kansas City. And now all of a sudden, folks in Jackson County, Missouri, are hearing cases that actually occur and involve Kansas citizens, Kansas property, Kansas damage. And while the substantive law is supposed to apply of Kansas in Missouri, by putting this into statute, we can point to that statute and we can say in Missouri, this is the law of the land in Kansas. This happened in Kansas. This is the applicable law to use, even though it's been removed to the state of Missouri. The issue for us is that in other cases or in other states where this hasn't been done, sometimes what happens is the legal system applies strict liability, which means that an activity is inherently dangerous, viewed as inherently dangerous. And as a result of being inherently dangerous, they don't actually have to show that there was intent to cause damage or there was any action that occurred by the defendant to result in the fire. That would be untenable for utilities, and that's why even states like California have dealt with this issue in law. The second thing that importantly that this does is cap punitive damages for wildfires resulting from a utility that were caused by a utility. All we mean to do is point to current Kansas statute that says $5 million is the cap and incorporate it specifically for wildfires. Again, that's in case we get put into another venue. That's in case there was some kind of erosion that was attempted through case law. This makes it very clear. For wildfires, the current cap on punitive damages applies. Now let's talk about property damage. It was our intent to take this and to give two fair ways to look at how to evaluate property damage. But we've had lots of conversations over the last couple of days with members of the ag community. Some do not like the definitions. Some are concerned this would create other downstream impacts. So we're currently talking with members of the ag community to see if there's a way to either change or amend the property damage section that is in this bill, or we would also be willing to completely remove it. For that matter, I think Representative Carmichael brought up some valid concerns on technical amendments. Those are also things that we would be willing to entertain. We are not trying to make this controversial. Finally, the last section merely says that this is an important issue, and the state regulatory body responsible for regulating us and other utilities should take a look at this. We would like for the Kansas Corporation Commission before middle of next year to convene all stakeholders and discuss what are the risks, are utilities prepared, are there any mitigation things that we can be doing, any strategies we should be doing to alter the risk, such as perhaps expanded tree trimming. There might be age of equipment requirements. There could be something that's called public safety power shutoffs, which are things that now happen in California and in Oregon and in Washington where certain conditions are met. The utility is told to turn off power to areas. We don't have that guidance today, and we don't think it's something that a utility should make in and of itself. We think this should be done before the state's regulatory body with all stakeholders involved, discussions of all consequences and potential costs. If we shut off electricity, that could hurt manufacturing. That could hurt farmers who are trying to dry crops in the fall. We need to be very clear on what the standard is for when we would do something like that. If we're going to expand tree trimming or do more robust replacement of equipment At certain ages, those are things that could cost consumers additional dollars of invested money, and that's something that we always talk about in this body. Again, that should be done in front of the Kansas Corporation Commission with all stakeholders involved. At the end of the day, all we would like to do is to codify existing law so that investors know when they're investing in us or other utilities in the state what their risk truly is and that it's reliable. And the second thing is have a conversation about this proactively before an event comes and shapes it in a response scenario. Thank you very much for the time. I stand for questions.
Absolutely. Thank you, Mr. Casey. Questions, Mr. Carmichael? Be nice.
Actually, Mr. Casely was very accommodating to me. He offered to discuss this legislation on Sunday morning before the Super Bowl. And we had a pleasant conversation on Monday morning and have exchanged some emails. So we're gonna satisfy Evergy, I'm sure. Mr. Casely, I think you heard my questions to Mr. Myers about the statute of limitations and the difference between date, if you will, of ignition versus date of damage. I didn't even put that in the context of a wildfire, which has multiple dates of ignition because they can start 2 or 3 different places. They eventually combine and then they run with the wind. Would your clients have any real problem with saying the statute, just like in anything else, begins at the date of the damage to the property concerned as opposed to the date a fire started in Oklahoma, in which case it'd be OG&E's problem?
Yeah, so no, I think that's a very reasonable thing. And as you said, sometimes with wildfires, they can run on multiple weeks. And the notion is not to arbitrarily or with any intent shorten the statute of limitations. 2 years from damage would be fine with us.
And under the language of this statute, I will probably give you that the so-called discovery rule may well not apply in this circumstance. Discovery rule is if you don't know your property's been damaged, then you don't have to sue until you reasonably knew until you knew or reasonably should have known of the damage. I assume people are going to know if their house burns down, so I'm not too concerned. I'm concerned, but I'm not concerned about the statutory provision. My second question is it your intent to only address damage to real property, which includes the improvements thereon, the house, the barn, etc., and punitive damages, or are you intending to also address personal property damage claims, cars, utility poles, those types of things?
No, that subsection D of the first section was meant to just give a framework to address how you would calculate real property damage. So houses, that kind of thing. To be perfectly honest, I think it's unlikely to survive additional conversation the way it currently is. There's some definitional concerns from members of the ag community. There's also some desire to not get into that potentially in this bill, and it's not our intent to limit economic, non-economic, and real property would be a subset of those things. So if that's the case, then addressing the negligence standard and punitive damages is sufficient for us.
Thank you, sir, and thank you, Mr. Chair.
Thank you. Further questions? Mr. Schreiber.
Thank you, Mr. Chair. Thank you, Chuck. I was reading an article when I was looking at this bill on kind of what California is doing and so forth, and the topic of insurance came up. I guess they had commercial insurance for a long time, but with their fires and so forth, they've gone to a self-insured model. But from just, I guess, general utility perspective, is the commercial insurance industry raising the costs of that insurance due to elevated risk for fire events and so forth?
It is when you can access it, and given the large number of fires that have occurred, particularly out west, even being able to access it is something that is getting more and more difficult. In California and some of the other states you've talked about, I think Utah as well, they are starting to look at a system where there would be a charge on customer bills that would establish a fund, $1 or so a month proactively till it got out to a certain amount. And then it would sit there to essentially insure against these kinds of issues. We contemplated putting that in this bill, but we did not, because what we thought the better path would be, instead of hitting this committee and this body with something that's brand new, we would rather have a chance for all stakeholders to get together in front of the Kansas Corporation Commission, discuss the risks and possible mitigation strategies. This would be one. If stakeholders say, hey, look, we don't, that's not something we want to do, then that's persuasive to us.
I appreciate the collaborative approach rather than dealing with insurance and different insurance models. So thank you, Mr. Chair.
Mr. Roth.
Thank you, Mr. Chairman. And my question, I may have missed the answer to this. It was brought up by Representative Carmichael. In the south tier of Kansas, many fires have started in Oklahoma and then progressed into Kansas. So does this bill address that issue of a fire starting in northern Oklahoma, north central Oklahoma, moving into Kansas and then damaging Kansas properties and lands?
To the extent that you deal with causation, if it started in for example, Oklahoma, and it moved north and east into Kansas, then what you would have is we would not be able to be held liable unless somebody met the negligence standard, meaning that something we did also additionally caused an issue.
So the map here shows that you do go down into Oklahoma just.
No, that's just the wildfire designation. So
Okay, gotcha.
we terminate right around Hutchinson, and then down, we go down the state line border almost to the entire southern border. So
Thank you very much. Thank you, Mr. Chairman.
Further questions? Ms. Bohai.
Thank you, Mr. Chair. Thank you for your presentation. You brought up California a couple of times. Do you know what their statute of limitations is and what their cap is for the damages?
no, I actually don't. I can look that up and get it to you, though.
And then you also mentioned that I'm going with the opponents have some issues with the bill currently. Were you able to collaborate before, or you're now collaborating?
So yes, so we've had conversations yesterday. It's when I was made aware there were issues, and we started to have a phone call. I would not say we are done yet. They would like some time to think through what the issues are, and so we're going to get back together with them today and make sure that if they have a concern, we try and address it.
Thank you.
Further questions? All right. Thank you, Mr. Casey.
Thank you, Mr. Chairman.
Do we have any other proponents that would like to speak? Mr. Stafford.
Thank you, Mr. Chairman and members of the committee. Good morning. Eric Stafford, Vice President of Government Affairs with the Kansas Chamber. I actually got my testimony drafted Saturday. I was doing really good, and I forgot to turn it in. But it was the most riveting and compelling testimony I've ever written in support of this bill. We will get a copy of that to you within the next few hours. So I apologize that I don't have anything yet submitted, but I had good intentions. Yes. So appreciate the opportunity to be here today in support of House Bill 2107. I'll be brief. Chuck did a good job summarizing a lot of the details, but we're here just generally. It doesn't matter what type of business it is, having a good, sound, predictable legal climate. You heard the desire to manage and mitigate risk and keep the system fair and balanced for landowners, property owners, but also for the business, the utilities in our state as well. That is important. To Representative Schreiber's question, the rising cost of insurance, whether it's general property and casualty or general liability, nationwide is rising. It is an issue. It's an issue that our economist has talked about through his competitiveness study that he's finalizing for the state of Kansas. But it is an issue nationwide, and Evergy is not immune, nor is any other utility from that exposure. Just generally in support of this, I think it does a good job of keeping a good balance, but but also providing necessary protections and going forward with the ability for the KCC to establish guidelines and criteria to follow, I think is ultimately a good thing to have a statewide policy on managing wildfires. So short and sweet, appreciate the opportunity to be here today. And again, I am sorry that I failed to remember to get that sent in, so my apologies.
Further questions for Mr. Stafford? Not seeing any. Thank you for being here. Appreciate it. And just get the statement or the documents up to Mindy when you get a chance. Thank you. Anyone else that would like to speak as a proponent? Okay, and I'm seeing written only testimony from Reagan McLeod with Kansas Electric Co-op, and you should also have some from Mike Morley with Midwest Energy. Opponents, I'm showing Claudia Hissong with Kansas Farm Bureau. Welcome to the committee.
Thank you, committee. Thank you, Chairman Delpting, for having me here this morning and the opportunity to provide testimony on House Bill 2107. As mentioned previously, we are in conversations with Evergy, but here today representing Kansas Farm Bureau are 30,000 farm ranch families that are all across Kansas. Wildfires are very impactful to our members. They are the ones that face the biggest outcomes and the biggest devastation of these events. So we didn't take lightly when we saw this bill, but based on conversations we are having and Evergy is committed to having with us, we think we can get to a position where we are neutral on this bill. So I just kind of want to lay out some of those conversations we've had and where we intend to go and what amendments we could see that could get us to a neutral position. So as mentioned, Section D is a point that we would like to either have eliminated or have changes where it talks about the award for damages. Those are our members, so either removing that subsection D or making an amendment to something that is favorable to landowners but also workable for utility companies is something we will be continuing to work on should the committee decide to work this bill. Also, as mentioned, negligence is a standard applied by the courts in Kansas today. So we are okay with codifying that in case law, codifying that existing case law into statute with this bill. To Representative Carmichael's point, we would support changing the language to the day of loss, exactly for the points mentioned that sometimes if it starts elsewhere, either your day of loss might not be for several weeks later. So we would be supportive of that change as well. As mentioned, wildfires and risk mitigation of those is something we continue to have conversations about. It's something very important. So we support Section 2 within the bill talking about the Kansas Corporation Commission outlining training opportunities to assess wildfire risk and mitigation, and we look forward to being involved in those conversations. Overall, I think we can get to a position to be neutral on this bill with the commitment of the proponents, and we look forward to having those conversations, and I will stand for questions at the appropriate time.
Thank you for your testimony. Questions? Okay. And I just want to reconfirm you are moving toward a neutral on the bill with negotiations here.
With negotiations, yes.
We'll make the bill brief reflect that. All right, thank you.
Thank you.
Next up is Jackie with Kansas Livestock Association. And your point?
Thank you, Mr. Chairman. I am Jackie Garagiola, there you go, with the Kansas Livestock Association. I'm our associate counsel, as well as a lobbyist for the association, representing our roughly 5,700 members, livestock producers across the state of Kansas. I really love it when Farm Bureau gets to stand up and give my testimony for me because we have been in similar talks with Evergy and been a part of these conversations. Our main concern was specifically with Section D of this bill. Once those concerns are taken care of, we could also move towards a neutral position. Our main concern here was not limiting damages that are available under law currently for our landowners when these devastating fires occur. Most of my testimony, much harsher than what you will hear from me currently, because I did draft this testimony before we had these conversations and were made aware of the opportunity to make some adjustments to this bill, is that we are not limiting damages for those individuals when these devastating events occur. And we've had some in recent years, specifically back in 2021, and we don't want those events that caused loss of homes and livelihoods and entire operations to be something that limits them in being able to recover on those economic damages. So that was our main concern with the bill. We'll be a part of these conversations, and if that language is removed or modified appropriately, then we can go to neutral on the bill. We are also would be supportive of the date of loss for the statute of limitations, as Farm Bureau mentioned. And then also supportive of the idea of increasing awareness through the KCC and making sure that there's appropriate education and mitigation. So with that, I'll stand for questions, but appreciate you allowing me to be here today.
Thank you, Ms. Garagiola, right?
Garagiola. Hey, if you're a big baseball fan and you're familiar with Joe Garagiola, yeah, it's a distant relative, but yeah, of my husband's family. So yeah.
Yes, Mr. Penn.
Thank you, Mr. Chair. Okay, Ms. Garagiola? Garagiola.
There you
I'm
go.
going to say it with the
Got
G.
it.
There you go.
You got it.
Trust me, you're not the first. I'm going to mess that up all the time. Hey, listen,
Okay.
good to see you here today. I just want to ask you a quick question about, we really respect KLE and the Farm Bureau, looking at customers and their protections that they have, consumer protection side of this house. Can you speak to that? Or is there a system in place already that would take care of those customers? I just want to make sure that
So
we address that.
typically, and I discussed this within my testimony, I mean, the standard here in the court system is negligence. We're comfortable with that standard and are fine with that being codified within this statute. That is their, they have the opportunity for civil litigation in instances like this, and we're comfortable with them having that option. The only thing we were concerned about is limiting their ability to recover appropriate damages in those circumstances. And so that option is still available to them. It simply codifies the negligence standard, which is the typical standard and one that we're comfortable with. The economic damages piece was our biggest concern. So we're fine with the process that's there. They still have to prove negligence, so there's an appropriate system for that in place, and one that we have to do, our members would have to do in any other circumstance as well. So that's fair across the board. We just want to make sure that we're not limiting them in any way from the opportunities that are available to them currently.
Yes, ma'am. Mr. Chair, thank you for that opportunity. I'm heartened to hear Ms. Garagiola's answer to that. It gives me a great sense of comfort to know that the language that's already there, the systems that are already in place are acceptable to you and they will keep you in neutrality.
Yes.
Sounds good. Thank you. I'll get you to neutrality. Thank you.
Yes, exactly.
Mr. Carmichael.
Thank you, Mr. Chairman. Thank you, Ms. Garagiola. Two areas of questions. First, I heard Mr. Casely say that they're not really trying to change the law of damages. And I read it, and I'm still trying to figure out how they're trying to change the law of damages, even though I trust my friend Chuck, of course. But you say that there's something in this statute that would limit your members' opportunity to recover damages. And since I haven't been able to find it, can you help me find it? What is it in this statute that needs to be changed to protect the rights of your members?
So subsection D is the one that was discussed. I think our major concern is that the way that those are configured, that there are instances where it might be appropriate to configure those in a different manner. And I don't know that we should limit that to the ones set forth within this bill.
Can you give me an example of what you're talking about? Because I can't figure it out. I mean, this seems to be a restatement of what jurors are instructed all the time in Kansas.
No, I believe that it's probably in line with what is in current case law. I just don't know that it is in every instance. I don't have a specific case from a member of ours and where that has been different. But codifying in something statute, whether as opposed to giving that opportunity to a judge, jury, I just believe putting those types of limitations, there could be instances where it's a special circumstance, it should be determined or calculated differently.
Okay. My second question has to do with the standard of care applicable to the utility. Kansas law does say that utilities, like everybody else, except maybe the government, are responsible for the consequences of their negligence. But it also imposes a somewhat different standard on utilities because of the nature of the instrumentality that they control. And I don't think it rises to the level of strict liability. I know that was Mr. Casely's concern. But if Kansas law does require utilities to abide by a high standard of care in view of what they do, I assume you're not wanting to change that back and make it a less rigorous test. Okay, I just want to make sure that's not where we're headed. Thank you.
Further questions? Seeing any, thank you for being here.
Thank you, committee.
Is there anybody else that would like to speak as an opponent? Yes. Not seeing any. Let's go with neutral, Mr. Snyder. With Kansans for lower electric rates. Welcome to the committee.
Do I need to start over? Am I good? Okay. California and Hawaii, those customers are paying billions upon billions of dollars for kind of wildfire reparations. I'm not really sure what they're being paid for, but it's been very significant, and we don't want those things to happen here in Kansas. So I do appreciate the cost containment kind of intent of this bill. But to further that just a bit and to protect customers, I do have an amendment in my testimony that I recommend that basically says that customers are not going to be on the hook for any damages that are paid when Evergy is negligent. Pretty simple, straightforward notion, so I hope you consider that. And with that, would stand for any questions.
Any questions for Mr. Snyder? Not seeing any. Thank you for your testimony, sir. So anyone else would like to speak as a neutral? Not seeing any. We should have written only from Justin Grady with the Kansas Corporation Commission. I am planning to work this on Thursday the 13th. I know, Mr. Carmichael, you had some really good questions and concerns about statute of limitations. So if
They'll be submitted momentarily to the reviser.
okay, all right. Further questions or comments? All right, with that, we will close the hearing on 2107. Let's open a hearing on 2225, prohibiting mobile home park landlords from limiting a tenant's access to communications and video services. Nick, you want to go through the bill?
Yeah, committee, Mr. Chairman and committee members. So House Bill 2225, as it's been introduced, I'm going to talk about just current law real fast, what we have in current law. So this bill amends the Mobile Home Parks Residential Landlord and Tenant Act. And within this act in current law, it prohibits a landlord of a mobile home park from imposing any conditions that restrict a tenant in the choice of a seller of fuel, furnishings, goods, services, or mobile homes. The key word being services, as you'll see here in the bill. And now the landlord can restrict access if it's necessary to protect the health, safety, and welfare of the tenants. So what this bill would do, House Bill 2225, it would amend that act to specify that the services portion of that includes cable television, communications, broadband, and telecommunications services. So what this would do is it would prohibit a landlord of a mobile home park from imposing any conditions that would restrict a tenant's access in the choice of or access to any such broadband, telecommunications, communications, and video services. And Mr. Chairman, if this is enacted, it takes effect on July 1, 2025 upon its publication in the statute book, and I'd be happy to stand for any questions.
All right, any questions for the reviser? Mr. Hoheisel.
Thank you, Mr. Chair. Thank you, Nick, for that breakdown. I'm just in my head trying to work through this, and I'm not familiar, too familiar with kind of right-of-way laws. And if I have a mobile home park and I don't currently have, we'll just say AT&T fiber, and I have some renters that want AT&T fiber, but I don't have it laid in the mobile home park, would I have to allow AT&T to come in to lay their fiber in order to have my tenants have access to AT&T fiber if that's what they choose?
I mean, the current law does specify that landlord cannot limit access to those furnishings, goods, or services unless it's reasonably necessary to protect the health, safety, welfare of the tenants. So I assume so. I'm not exactly sure how.
In current law, you assume so under current law?
Yes, and then this bill goes further to
just clarify that.
Clarify those services, because I bet you you're going to hear a proponent behind me kind of talk about a situation where they've gotten into some hardships in applying the current law, and that's probably the reason for specifying that these services include those communications, broadband, telecommunications, and video services. So I think in your situation that you're posing, a landlord would need to allow a tenant's access to any of those services unless they need to do something to protect the welfare of the residents.
I appreciate that. Thank you, Mr. Chair.
Further questions? Not seeing anything. Mr. Schlangensieben?
Thank you, Mr. Chairman. I'm going to piggyback on that question because I'm not sure I really understand it. So somebody wants AT&T fiber. If AT&T wants to lay that to the customer's door, I can understand that the rentor can't impede that desire. But to turn it around and say, because that person wants access, I now somehow have to pay for that cable to come in is saying something quite different. And so I guess my question is, which way around is it?
So that's a good question and maybe a good distinction to make. This bill is only dealing with how a landlord and the restrictions that a landlord in a mobile home park places on its tenants. This doesn't necessarily require AT&T. If a mobile home tenant wants AT&T fiber, it doesn't necessarily require AT&T to go lay that fiber and get to them. Now, if it's available and a company is has access and can lay, or string a wire, the landlord in this bill would not be able to prohibit that access.
Thank you. Thank you, Mr. Chair.
Further questions? All right. Thank you, Nick. First up in person, we've got Ethan Kaplan with Idea Tech. Welcome to the committee, sir.
Thank you very much. My name is Ethan Kaplan. I'm General Counsel, Director of Broadband Advocacy at Idea Tech Telecommunications. I've already provided my testimony. I know you guys are real busy. I don't want to have to make you listen to it again, so I won't repeat what I put in there. I just want to kind of summarize where we're coming from. And I do take umbrage. I heard before that someone said he was a recovering attorney, like we need a program or something. I think we're okay, and I'm still practicing. So, but first off, I want to say that one of the things that we've at Idea Tech kind of have found works really well is when we're running into issues, we don't think selfishly, how can we solve this for Idea Tech? We think, okay, for the broadband community as a whole. We did that last year with the right-of-way bill, because it's also important for the city, for the counties and the state to have certain clarifying language, because I'm sure you are very busy and you don't have time to figure out and go through old statutes and figure out what's going to help and what's not. And so what we've done here is, and I've, as General Counsel, I've been given questions numerous times over the last couple years about a mobile home tenant at a mobile home park wanting to get Ideatec fiber, and the owner of the mobile home park is not permitting them to do so because it's crossing their land, essentially. It has nothing to do with whether they have agreements with other people. I know that's covered, under certain other regulations and guidelines. This is simply about accessing private property. And I put in there one thing that we have to do is there's a delicate balance because we understand that there are property rights here involved. And we understand that if we disturb those property rights, that's something that we have to account for. And so it's not our goal here to invade or cause a lot of damage. It's simply to provide the essential services to the tenants. And that is, as the revisor stated, is exactly the current law as it states. It restricts the landlord from providing or from restricting choice of these services. So if Ideatec or AT&T or Cox or anyone providing internet service wants to give a mobile home tenant who has inquired about their services their product, the issue is going to be whether the property owner will allow them to actually get the line to their house. That's where we're having the issues. Right now, as it states, it's not as clear, but when it states services, we'd like that to be clarified to account for the essential service of what we are involved with, is broadband. Because as we all know, based on many discussions that you've heard, that it is now a utility essentially and a necessary service. And by restricting access, what they're doing is basically not allowing tenants that choice, which would be contrary to the statute. Now, one of the things that we have to look at is whether cities or counties can make that mobile home park owner provide that access. And unfortunately, that's not a done deal. Basically, the counties, as you know, do not get into franchise agreements with broadband providers. That's a city-only thing. And the cities also don't want to have to deal with that because they feel it's a private issue. And we don't want to put that on the cities because, one, that puts more pressure on them, but it also causes more delay in getting these services to the tenants because now the cities somehow have to get involved. So what we've done here is we've taken a look at this statute and we've determined that one way we can help everyone solve this is by clarifying the language, and that's what we've tried to do here. It's not trying to get into a fight with whether services, broadband is covered under services, whether choice includes access. This simply lays out what exactly that includes. Now, there are safeguards in the statute already, the reasonableness, whether there's a health, safety, that sort of item concern. And so there are protections for the landlords or for the mobile home park owners if there's going to be something that affects the safety or health or welfare. The other thing I want to discuss quick is it's more on an economic thing, and it's really about the expansion of broadband. I mean, we've stressed the expansion of broadband in Kansas, and I know at Ideatec, and I don't know if this has been the case for other providers, but without this language, we personally have been very, I guess, resistant or slower to make these type of investments in providing the mobile home tenants the fiber. Because we're worried based on our experiences that it's going to be blocked. And so we're going to get fiber up to these mobile home parks, and then we're not going to be able to get it to any tenants. And so they're going to see Ideatec fibers available, or AT&T fibers available, or whatever fibers available, and they're not going to be able to get it unless there's a fight. And we don't want to do that. So we're asking you today to basically provide this modified language that we've included to allow us to proceed with these investments in timely and more equitable manner. Again, I don't want to reiterate my testimony, so I will stand for questions. Thank you very much for letting me speak in front of you today.
Absolutely, Ethan. Any questions? Representative Hoheisel.
Thank you, Mr. Chairman. Thank you, Ethan, for being here today. why are we being specific to just mobile home parks? Why aren't we including apartments or private residences that are rented out?
I'll tell you that, because that is under a different statute. And when we were looking at, we were dealing in the past couple, times that I've actually got an email saying, what do we do here? We were dealing with mobile home parks because there are different, obviously, statutes dealing with residential, the standard residential landlord. There are definitely, we talked with another provider and we addressed this, and we had initially thought about actually amending the standard, but there were some concerns as to getting into franchise and MTEs and all that sort of language. And so we felt that at this time, with the schedule as it is, this would be the easiest one to solve the issue that we see that won't invade any other concerns. I think one of the big things that came up with the franchise agreements and the broadband requirements for needing that. So that's the only reason. So maybe at some point in the future, once we can all come together and collaborate, I do know that this committee likes collaboration with, and they like to have something sort of more neutral. And so that's why we held off on that actual statute.
Mr. Chair, if I may, from revisers or research, look into what the wording is, especially with subsection B there, what they're trying to amend for apartments and private rentals, homes that are rented out. If that language there kind of matches, starting on line 27, matches what we have for apartment complexes and
Nick, would you
rental
like to
homes.
answer that?
And it doesn't have to be now. He can just follow up whenever he has that if he doesn't have the answer. Thank you, Mr. Chairman.
So there is a similar provision in the Residential Landlord and Tenant Act. Again, this is the act that deals with residential landlords and tenants, not mobile home tenants and landlords. The similar language in this statute says that the landlord shall not interfere with or refuse to allow access or service to a tenant by a communication or cable television service duly franchised by a municipality. So you can, those keywords, the communication or cable television service is present in that statute.
Which statute is that?
Thank you, Mr. Chairman. That is KSA 582553.
Further questions? Mr. Schreiber.
Mr. Chairman, I'm still reading, so if somebody else has a question, you can go over me. Thank you.
Okay. Is there anybody else that would like to ask a question? Not. Yeah. Would you like me to recess for a little bit, Mark? Hold on a second. Go ahead, Mr. Carmichael, if you got one.
Thank you. In the testimony of Ms. Smith from the Kansas Manufactured Housing Association, she cites multiple FCC regulations that she claims already address this problem. Is that correct? And if so, why do we need a Kansas law?
I don't believe that's correct. I think what they may be referring to are MTEs, and again, that's dealing with the Residential Landlord Tenant Act. We're talking the mobile home park, and specifically what we're saying again is the counties, and I just to go back to the question that was previous, as you can see, the language in the statute does say a duly franchised, and that's where the issue was coming in, because now you're opening another sort of bigger discussion. So that's what I think they're referring to. Other certain things like there's the Cable Communications Policy Act and things of that nature. That's more of a franchise thing as well, where it says that local governments have the authority to get involved here. That can't occur where, especially a county has no power at this point to require a private, property owner to do that, because there is no franchise agreement. So
Ms. Smith's testimony says that the FCC regulations already specifically include mobile home parks. So I'll look forward to page, line, and verse when to find out about it, because apparently that's law you haven't heard of.
Well, as far as in this 5 seconds that you've said that, what I'd say is I'd have to review that and see exactly what it addresses. But again, we're talking about this language that we're asking for is simply clarification, so that we don't have to now delay and get this FCC involved. It's clear that with the intent of the language as it is, the choice of services is if someone wants desired service for fuel, they'd somehow have to have access to that fuel. Here we're talking broadband fiber, where they'd have to have access to it, because you can't just choose it and not be able to get it.
Okay. I think Mark's about, no, he's still reading. I'm running low on questions, Mr. Chair.
There you go. Mr. Schreiber, take it away.
Okay, thank you for the pause here. And so in the bill, it talks about 58-25, comma 111. It's talking about public utility services, but you're not a public utility.
We're, as a telecommunications provider, yeah, I mean, we're
You're not under the KCC jurisdiction, are you?
we are.
They set your rates and stuff, or?
Well, we have I mean, we're a telecommunications. We have a certification and everything under them, so.
Okay. So what would prevent a tenant then to work with other tenants in the mobile home park and go to the landlord and say, I'd like IdeaTech or AT&T or somebody, and the landlord says, okay, if everybody agrees to this, then what would prevent them?
that would be very ideal if that would happen, and we'd go and door to door and say, you know, you want IdeaTech fiber, go talk to your landlord. The question is going to be if the landlord, now what authority, if the landlord says no, what authority do we have to address it? None.
But it's his property, right? Or her property?
The property, it is, yeah.
Yeah.
It is.
So wouldn't they have control over what goes on their property?
Well, by the statute that's already in place, they don't have control over choice of services. They can't restrict the tenant's right to their choice of services. What we're saying is that broadband, being an essential service at this point, and whether that's IdeaTech, AT&T, whatever, we can't provide that service to those tenants if we don't have access to those tenants. They can choose to use our service, but as it's written, I could see the argument coming from a landlord that there's no right to access. So if they choose us, I mean, it just seems contradictory. That's why we're here, is to try to clarify how do we get a tenant who chooses our service, how do we get them our service? And right now it's muddled as to whether this statute would require a landlord, a mobile home park owner, to allow us to cross either aerial, under, whatever, to basically access that, because it's their private, and that's why I said at the beginning, we have this delicate balance. It's not a right-of-way, it's not a public right-of-way, so.
Right. So I go back to the public utility and essential public service that you're talking about. For electricity, the utility is required to serve them. But there's not a statute that requires them to have a telecommunication service, is there? Or
well, not a statute requiring the landlord, you mean?
Or yeah, the landlord to provide a service.
No, there's no statute requiring the landlord, but there is but there's a statute preventing them from allowing one of their tenants access to these services. Again, fuel, goods, and I don't recall the other service that was listed, but those sort of services are already included in there. So if another let's say fuel source comes in, how are they going to get their services to the tenant without crossing the private property? It seems like they would be then running into the same sort of issue we are.
But the utilities have designated territories, so like we don't have a deregulated environment here, but
yeah.
So anyway, okay. Thank you, Mr. Chair.
Ms. Bohai.
Very quick. Thank you, Mr. Chair. I would just wonder how many times IdeaTech has been thwarted, for lack of a better term, in providing service to these types of situations.
Sure. I would say probably with me personally and the issues I've gotten, I'd say 3 or 4 in the last 1 or 2 years. The most recent issue, and I can get clarification on where it was, but it was really the one that made me look at the statute, and I was looking initially under the residential standard to say, you know, why are we not allowed? Because under the standard, when it does say communications, and then I said it doesn't say anything about franchise in the counties, because that's where this was outside of the city. And so that's when I looked at the mobile home park thing. I said, well, yeah, well, there is an argument to be made that it's muddled, that they could choose our service, but there's no guarantee they're going to get access to it. And so, yes, I guess the question, to answer your question, it's been a couple of times. The other problem is, as I mentioned, this is pretty much a problem with investment and building to these mobile home parks. And so we'd like to speed up that process. Thank you.
Showing 2 final questions. Mr. Penn?
Thank you, Mr. Chairman. Thank you so much for your time here today, sir. Just a couple of quick questions, and I'm so sorry that I had to step out, but you may have already addressed it, and if you have, that's fine. I'll go back and check the video. On top paragraph of page 2 of your testimony, says another addition to the bill we've requested is that being able to refrain from imposing conditions restricting choice. I guess the biggest question that I have is when we're talking about right of way and whether or not you are amended into statute as a definition of a service, would your particular extension of your service, who pays the cost for that? You have the mobile home landlord, if you will, that's their property, and you're extending the service to those tenants who are on that property. According to that paragraph, there has to be an introduction of all of your different equipment and everything in order to deliver said service. Does that translate to the landlord paying a fee to host and house that? And does that fee get passed on to the end consumer in uppage of their rates of rental or whatever the case might be for their mobile home to be on that property? Or does the company do it on their own dime?
Sure. No, that's a great question. I appreciate you bringing that up. Essentially, the company would do it because what we're doing is we're installing our fiber. It's over the landlord's tenant. They're not the ones who are going to have to pay for we're going to have to repair it just like we would a normal household that would require us to get it. So we would foot that bill. It wouldn't be them. If there's an installation, I mean, I don't anticipate there being sort of any other fees or anything, but if there's like an installation fee or something, that would be on the actual mobile home owner who wants the services to get it.
Mr. Hoheisel?
Thank you, Mr. Chair. Due to the time, I'll forgo my second question.
Okay, I appreciate it. Would you like to ask a question, Mr. Wilbur?
Thank you, Mr. Chair, and thank you for being here. You conferees bring a valuable asset to us because we're learning all about this. Sure. I probably should have asked this question after the other conferee spoke, but I was going to ask you, have you had the opportunity or taken the opportunity to sit down with the Kansas Manufactured Housing Authority to see if there's someplace we can get together?
No, actually, well, I have not, because the first I've heard that there's opposition was today. I'm happy to do that going forward, obviously. The only people that we looked at, like we spoke with, as I mentioned, another provider about it. They didn't have any issue with this portion, which is why I'm here today, obviously. It was the other statute that they were kind of hesitant about, and so we didn't want to push that at this point.
All right. Thank you for being here, sir.
Thank you very much. Thank you, everyone.
Is there anybody else who would like to speak as a proponent? Not seeing any, we move on to the opponents. Ms. Smith with Kansas Manufactured Housing Association. Welcome to the committee.
Good morning. I am Martha Smith with Kansas Manufactured Housing Association. I appreciate the opportunity to comment today. It sounds like you guys have a lot of questions about the proposal. I did attach to my testimony the FCC Consumer Guide, which does specifically state that MTEs or mobile homes are MTEs, and that is in the third paragraph of the Consumer Guide. It also goes on to say the FCC's frequently asked question. One tenant has asked the FCC, it says, the owner of my building won't allow access to my desired provider. Are they violating the FCC rules? And the FCC comes back and says, the rules only apply to the providers. They don't apply to the landlord. However, it says, while a service provider may not enter into an agreement that grants exclusive access to the MTE, which remember, were included in that definition, a landlord may still choose the provider it allows onto, or into in this case, into the building, even if that means only one company provides service. So that is the FCC, that's straight off the FCC's guidance. And I believe a representative had a question about whether or not we were considered MTEs. And that is in the third paragraph.
Any questions for Ms. Smith? Representative Carmichael.
I'm sorry, thank you, Mr. Chair. I'm sorry, Ms. Smith, but I don't follow what you're telling us here. You read to us something about entry into a building, and so that tells me we're talking about apartments, not a mobile home. And I don't recall hearing you read to us from the CFR or the statute where it is that mobile home parks are included. Could you help me again, because I just must have missed that part of your testimony.
It's right here in the FCC's consumer guide.
I looked at the consumer guide and I don't remember seeing that, so give me just a moment.
Sure.
Mr. Chair, I know we're running out of time. Okay, now where in this consumer guide does it say mobile home parks are covered? I see that it says MTEs and it talks about buildings.
Right.
Where does it talk about mobile homes?
In the second sentence, it says.
Second sentence of what? I'm sorry.
Of paragraph 3, where it says, is my building an MTE covered by FCC rules? The second sentence of that first paragraph says, MTEs also encompass centrally managed residential real estate developments, such as gated communities, mobile home parks, or garden apartments.
I now see it.
Okay.
Thank you.
You're
now,
welcome.
my question is, if you're already required to do this, why is there a problem with us enacting a state law that also provides the same thing as is apparently already the law? Why don't we go ahead and give Idea Tech what it wants, because you're apparently already abiding by this?
But the FCC says that a landlord does have the right to select the providers that comes onto their property.
Oh, exclusivity rather than competition. You want to preserve exclusivity and the payment you receive from that chosen provider and defeat competition. I'm with you now, I understand.
Further questions? Ms. Bohai.
Thank you for your presentation today. To further this line of question, is broadband currently at some of these mobile home parks? And this is a different provider to provide the competitive pricing? So they already have access to broadband, but there's another provider that could provide them better access? Is that the problem?
When I put a survey out to my members asking whether they allow all of the, whether it's broadband or telecommunications or cable, I only had 2 come back and say that they do not allow additional providers. So they do come into our communities, our mobile home parks. In fact, Idea Tech has recently come into one of our mobile home parks, and they've switched over to Idea Tech. So
Further questions?
I would like to mention too that the average age of a mobile home park in Kansas is 33 years old. So, and our homes have gotten larger. So the infrastructure in some of the older parks, especially with higher density, the infrastructure may not support allowing every single provider coming in laying fiber. It may cause an overload. It may not allow the service to function like it should. So that is also a concern.
Okay. Further questions? Thank you for being here. Would anybody else like to speak as an opponent on the bill? Not seeing any. I don't see any neutrals. Anybody want to speak as a neutral? Not seeing any. We will close the hearing on 2225. I'd like to open the House Bill 2110 for final action. Nick, would you like to, one moment, please. Mr. Penn?
Would you like a motion on that, Mr. Chairman?
Not until Nick explains what we're doing.
Roger that.
Go
Give me a
ahead, Nick.
huckleberry.
Yeah, thank you, Mr. Chairman. So committee, real fast, House Bill 2110 would amend this is the Kansas 911 Act follow-up bill. So here's kind of the main points of this bill. It would remove the requirement that the state board, the state 911 board, contract with a local collection point administrator for services. The board would retain the authority to continue to contract as necessary for necessary services. It would reschedule when the funds are created in the state treasury, and then also it would reschedule when the date of the bulk transfer of 911 monies that are held outside of the state treasury be transferred into the state treasury. It would require that immediate transfer of monies into the state 911 operations fund. An amount of $1 million would be transferred on July 1, 2025 into that state treasury 911 operations fund. And then it would also authorize the board to make discretionary annual transfers from the operations fund to the state 911 grant fund for amounts that are unencumbered from the prior fiscal year. And it would remove the 1 cent transfer fee cap on the state 911 grant fund as well. And I'd be happy to answer questions.
Questions to the reviser? Not seeing any. Mr. Penn?
Yes, Mr. Chairman?
Would you like to make a motion, sir?
Mr. Chairman, I move that the committee open and pass out favorably House Bill 2110 for passage.
And I see a second from Mr. Roth. Committee discussion on House Bill 2110. Not seeing any. Mr. Penn, would you like to move your motion?
Mr. Chairman, I move.
All right, you heard the motion to pass out favorably House Bill 2110. All in favor, please say aye. Any opposed? Motion passes. Would you like a red? Go ahead, Mr. Carmichael.
I'd like my affirmative vote recorded in the minutes of this meeting. Thank you.
Anyone else would like their votes recorded? People pointing at somebody. Oh, Mr. Schlingensiepen, you'd like yours recorded also? And Ms. Melton too. Okay. Anyone else? My ranking member. All right. That does conclude what we were going to do today. You would like? Yeah, go ahead, Mr. Berquist.
I just wanted to make my attempt at Jackie Garagiola. Thank you.
Okay. Done well. Done well. Yeah. Okay, we're going to meet on Thursday, February 13th, and we are going to have final action on 2107 and 2225 that we heard earlier. Any questions or closing comments before we close here? All right, we are adjourned. Thank you.